I also want to thank our marketing director, Denise Chaz, who pushed me outside of my comfort zone to do this and to share this information with you today. Hopefully it'll be worth your time. What we're going to do today is a brief review of the components of an estate plan and then highlight a few key points that you should be discussing with your advisors now, before the end of the year, because of some expiring tax code provisions. The thing about estate planning that disturbs me is that too often people put it off or dismiss the idea of doing an estate plan entirely. And the reason it disturbs me is that I see the impact on the families, namely a lack of clear direction, sometimes unnecessary taxes and fees, and often a sense of confusion that's left behind. If you think it's too overwhelming to do an estate plan, even the most basic one, consider what you're leaving behind for your loved ones to deal with should something happen to you. And if you come away with nothing else from our time together today, it's this. It's better to do something at all than to do nothing at all. The first steps involve meeting with your accountant and your attorney. These professionals know the process and will make sure that you don't shortchange yourself or other beneficiaries with needless taxes, fees, or confusion. Many people underestimate their worth, but working through this process will help you identify your assets, including investments, retirement accounts, insurance policies, real estate, and business interests. Once you've detailed those assets, you'll need to define your intentions, carefully consider the assets, and identify the heir or destination for them. Open discussion with family members during this process can avoid a world of problems later. Not surprisingly, some important documents will need to be drafted during this process. One of the most important documents is your will. It's a misconception that you must be very wealthy or have a very large family to need a will. Everyone should have a clear and precise map of how they want their assets distributed. You may also find it beneficial to set up one or more trusts. Trusts allow you to put conditions on your assets on how they're distributed, reduce estate and gift taxes, and can better protect your assets from lawsuits or creditors. One of the most common, called a revocable trust, is also a useful way to distribute assets discreetly and avoid probate fees. There are many different kinds of trusts, and we'll discuss a few more of those in a moment. A durable power of attorney is also a powerful tool. It gives broad powers to an agent you choose. It's most often used to give direction about financial matters and can be designed to be effective immediately or upon a triggering event such as a disability or incapacity. Under a change in law in Delaware back in 2010, both you and the agent must sign their consent. So if you have an older durable power of attorney, you may need to revisit the wording with your attorney for it to be effective. The last must-have document is a healthcare directive. This document greatly reduces the stress on your family by establishing clear instructions of what you want to have happen should you become ill or incapacitated. By creating this document, your named agent can feel secure that they're doing what you want them to do. We've seen this document also evolve in the drafting over the years as the medical community has directed more specific terms be included. In case you're wondering, it's not uncommon to name different people to be responsible for your financial rather than your medical needs. And a word about selecting your agents, trustees, and executors. Talk to them as you're drafting the documents so they understand what you're asking of them. These are big responsibilities and not to be given or taken on lightly. There are a few more steps to follow once the documents are signed, and if you stop with the documents and just put them on a shelf somewhere, you'll most likely fall far short of achieving your goals. These 3 follow-up points are what we're going to spend the rest of our time on today. After you've established what your assets are, you then need to assess their value. For real estate, you might want to hire an appraiser. Excuse me. For your business, you might want to conduct a business valuation. Neither of these are crucial at this phase unless you're looking to make gifts of those assets, though, and we'll talk a little more on that later. You need to review how your assets are currently titled and how that title might need to change once you've identified where you'd like them transferred. Here are some broad guidelines. Private company stock should be titled in the name of your revocable trust to avoid probate and maintain your privacy. Life insurance policies should receive careful consideration, and they may also belong in a trust if you anticipate that your estate will be taxable. Retirement plan assets go directly to your beneficiaries, so make sure you evaluate primary and secondary beneficiaries every few years. And a few strategic thoughts here. You can change the beneficiary of your retirement plan without changing other estate planning documents, so it's much more nimble in that regard. If you're considering a Roth conversion, 2012 may be a good time to do that for part or all of your retirement assets. And if you want to discuss that point further, let me know. If your retirement assets are a traditional 401k or IRA, and you have any charitable intentions, these are good assets to leave to charity. Left to your heirs, those same dollars will be taxable to them when distributed, but that's not the case with a charitable organization so long as you make sure it's one that's recognized by the IRS. Your home, also known as your primary residence in the tax code, if it's jointly titled, will directly go to your spouse and is not subject to probate. But be careful to consider that if you're remarried or if you owned the home prior to your marriage, the home may not be jointly titled. If your home is not jointly titled, it will pass by the direction of your will. It can be placed in trust for your spouse's lifetime and then passed to your next generation of heirs, for example. Lastly, you could consider other real estate. Again, if jointly titled, will pass directly to your spouse, not subject to probate. But real estate can be a good candidate for gifting. Say a beach house that you could contribute to a family trust or limited partnership and make gifts to your children over time. The next thing you'll want to do is draft a letter of instruction, and I can't stress enough how important this is. The slide shows a number of things you should consider explaining since you won't be around when the time comes. For example, your trustee or executor may not know who your trusted advisors are, and those are the people best suited to help them follow your plan. They also may not readily know the location or even the existence of some of your key assets, such as real estate titles, bank accounts, life insurance policies. Consider to what degree you handle your finances online, including automatic payments that may be scheduled. It will be important for your trustee or executor to be able to access and manage your online accounts. Lastly, consider whether you have any sentimental or collectible items that you want to pass directly to specific individuals. You may want to leave specific instructions regarding your funeral arrangements, how you want a surviving pet taken care of, or how you want your obituary handled. For any of those unique things, if they're not mentioned in your will, this is a good place to describe them. Lastly, gifts are an option for distributing your estate during your lifetime and something you should be thinking about right now. The reason it's important now is that without further action from Congress, the current $5 million lifetime gift exemption is set to expire on December 31st of this year. This, coupled with historically low asset values for many businesses and real estate, makes it the perfect time to consider a gift in 2012. One benefit of gifting during your lifetime is that it allows you to observe firsthand how your beneficiaries handle increased wealth. This gives you time to offer suggestions, further educate them, or alter your estate plan if you decide that they're unable to manage the assets you've designated for them. There are some dramatic changes that will occur after 2012 unless Congress acts, and given the gridlock in Washington, it's anyone's guess as to when they will reach a consensus on any bill that addresses these issues. Here's what's going to happen. The lifetime gift exemption will drop from $5 million to $1 million. In short, you could make a large gift in this year without owing any tax, and the same gift next year is going to result in a large tax liability. The issue of portability is also at risk and has been a phenomenal provision over the last few years. The way this works is that if there's a disparity in how assets are owned by a married couple, one spouse could use, say, $2 million of their $5 million exemption, leaving the other spouse with the additional $3 million without penalty. This portability is at risk. And the last point I'll make is that the estate tax rate is going to take a huge jump next year from 35% to 55%, a 20% increase in tax on assets in excess of $1 million. Think how quickly that can add up and what your heirs could do with that money instead. There are also a few other types of taxes and fees that can affect your estate. For example, Maryland currently only has a $1 million exemption and imposes an estate tax on the transfer of wealth in excess of that. There are some creative options for proper Maryland planning of an estate in excess of $1 million. Delaware has a $5 million estate tax exemption currently, but Delaware follows the federal guidelines, so that our exemption there will go down next year also. Probate and associated fees are also a concern. By properly titling your assets, you can greatly reduce these fees, which can run up to about 2%, and then the additional cost of professional fees to navigate and comply with the required filings and processes. Identifying gifting opportunities is the next step. Again, the rules will change at the end of this year, so it's important to decide now if this makes sense for you. If you own private company stock, your company may be just beginning to recover from the recession, which could result in it being currently undervalued. You can also take advantage of discounts for lack of marketability and minority interest. This strategy would be undertaken with the use of an accredited business valuator to record the value of the transfer in case it's examined by the IRS. Another great opportunity right now is real estate. Values are historically low, and here again you would want to have the property appraised to substantiate any transfer. Some nuances on the real estate topic are to consider selling or gifting out-of-state properties, which can avoid having your heirs go through probate process in multiple states. Another strategy is to consider placing real estate in a separate entity and gifting small interests over time. Depending on your specific situation, there are other options available also. I'll name a few. A lifetime credit shelter trust is designed to allow married couples to take full advantage of the lifetime exemption for estate taxes and to minimize federal tax on their combined estates. Charitable gift annuities are a way to perfect a charitable intent while retaining income currently, and there are current tax advantages to this strategy. And one last example I'll mention is a grantor retained annuity trust. These trusts are set up as an annuity where the donor receives an annual payment from the annuity for a set period of time, and at the end, any remaining or excess value in the trust is passed on to the named beneficiary. Any of the options we've discussed today should be executed in careful coordination with your advisors. As you can see, there are a lot of viable strategies, and each person's situation is unique. We look forward to helping you navigate your options so that you're happy with the result. We've covered a lot of ground today, and it's being recorded, so if you want to go back later and listen again, you're welcome to do that. A link to today's presentation will also be posted on our website and included in our next newsletter. Okay, so now I see we have a few questions waiting. Let's see. Please feel free to ask any, if you don't see it, there's a questions block to the right, and if we don't get through all of them today, I'll be sure to follow up with you after the webinar. One here says, can I be the trustee of my own revocable trust? The answer to this is yes, and in fact it makes this a very low-risk planning tool. You control the terms of the trust and what assets go into it during your lifetime. At your death, if you become incapacitated, your successor trustee takes over, and this can be your spouse or any other person you choose. Let's see, the next question. Why would I want to consider a Roth conversion of my retirement assets in 2012? Okay, the answer here is because you're expecting to see an increase in the income tax rates in coming years. And in fact, there's already a 3.8% tax rate scheduled to take effect on investment income next year. While a Roth conversion or retirement plan distribution won't be subject to that 3.8% in future years, it can raise your total taxable income to the point where your investment income then becomes subject to the additional tax. I think that's all the questions we've got. My email's on the slide, so if you think of any later, feel free to email me. I'd be happy to chat with you. And thank you for your time today.